Hello, I'm Alexander Cross, attorney, criminal law. If you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our YouTube channel, Alexander Cross. Here I'm going to read a question that we received here on our channel. Let's see. We violated a criminal restraining order. My wife and I began living together again after a domestic violence case. I wanted to punish my daughter, my 16-year-old daughter, and I hit her. She called the police and I was arrested. What can happen? Well, there's a couple of things. Number one, let's focus on the violation of the criminal protective order. See, when somebody is accused of domestic violence in criminal court, the judge will issue a criminal protective order that is generally valid for 3 years. Now, the victim, she could theoretically go to court and tell the judge, Your Honor, I'd like to have contact with my husband because we have kids in common, or because of this reason, that reason, I'm not afraid of him. Sometimes the judge will be like, fine, whatever, and will issue a peaceful contact order. Sometimes the judge will be like, no, I'm not going to issue that. Or sometimes they'll say, fine, go take this class. If I'm satisfied that you are well aware of the risks that you are taking, well then, great. I'm going to allow you to stay in contact with your husband or ex-husband or boyfriend, or et cetera, et cetera, et cetera. So if you don't ask permission of the court to do that, you can't have contact with your husband or with your wife. You can't do that. Otherwise, that would be a violation of Penal Code Section 273.6, which carries up to 1 year of the county jail. They could also charge you with disobeying the court, which is a violation of Penal Code Section 166(a). But regardless of that, you can't do that without permission from the court. Now, there is one slight exception. If there's an emergency situation, like let's say you need to pick up a kid from school, or your wife can't pick up the kid from school, and you need to stay in contact with for some reason have to stay in contact, that can be done by way of an attorney, because attorneys are considered officers of the court. So you can contact an attorney so that the attorney can contact your spouse or ex-spouse or whatever. But beyond that, you have to get permission from a judge. Now, the other aspect is the whole part about hitting your 16-year-old daughter. Now, corporal punishment is legal in the state of California. Generally speaking, with an open hand, you can hit your kid, provided that he or she is under the age of 18. Once a kid is over 18, you can't hit them. You better just do a 3-day notice to pay rent or quit type of thing. You're going to have to just kick them out of the house that way. But when they're a minor, you can hit them with an open hand, but it needs to be reasonable compared to the alleged infraction that the kid committed. You can't be kicking a kid in the head. You can't be hitting him with a stapler. You can't be, hitting him with a bat or pointing a gun. I mean, you can't use a physical object to hit somebody. You can't. That would be assault. That could theoretically be assault with a deadly weapon, a 245A1. Any solid object could be considered a deadly weapon that carries up to 4 years state prison. But with child endangerment, or they could file a charge of child endangerment or cruelty to children, which is a violation of Penal Code Section 273A(a), which is a felony that carries up to 6 years in the state prison. So, in a situation like that, you have a potential of being charged with a 273A(a), which is a felony, which is cruelty to children, or you could be charged with a violation of disobeying the court, which is a 273.6. You don't want to do that. In a situation like that, if the police showed up and you were still in the house, that alone would show that you were clearly in violation of the 273.6, which is violating the criminal restraining order. But also, if the kid had bruises, marks, cuts, that kind of thing, based on the corporal punishment that you've administered, well, there you go with the 273AA. So you really have to look at the evidence in this case. Obviously, the 273.6 would be relatively simple for the DA to prove. So the focus really is going to have to be on the 273 AA, the child endangerment or the cruelty to children, because that's really going to be the most important aspect of the case, because that would really make a huge difference on the eventual punishment. Now, if it looks like they don't have enough to convince the jury that you actually committed the offense, well, then in that situation, it would be a good idea to start bugging the DA about getting a dismissal. If they're not willing to go with the dismissal, well, then let's talk about a jury trial, when they will have to bring in 12 people from the community who will have to decide if you're innocent or guilty. If they find you innocent, they dismiss the charges. Of course, if it looks obvious that you committed the offense, if it looks like, oh yeah, if I go to trial, I'm dead in the water, well, then you know what? That's when it'd be a good idea for the attorney to start the process of cutting a deal with the DA's office to avoid a relatively harsh punishment. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our YouTube channel, Alexander Cross. Or if you have been accused of having committed a crime and you need representation in court, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677.